Well, hello. Once again, you're listening to the Big Picture Retirement Show. I'm your host, Rick Rivera. Want to thank everybody for tuning in. Real quick, for those of you that are new listeners to the show, the Big Picture Retirement Show is about sharing strategies with you. Maybe you're 5 years away from retirement. Maybe you're already retired. What we like to do each and every week is share strategies with you that allow you to enhance what it is that you've been able to accomplish when it comes to your retirement planning. So we talk about a variety of different topics each and every week, whether it be taxes, Social Security, pensions, trust and will planning, long-term care, life insurance. The list goes on and on. But again, all these things tie in together. And of course, if you have any questions about any of the topics that we talk about on today's show, or maybe you have questions about topics that we didn't even get a chance to cover in the show today, you have questions of things outside of the topics we talk about today, please feel free to give us a call, toll free, 800-700-1980. You can also reach us on the web at safeguardinvestment.com. Again, that's safeguardinvestment.com. And on the website, it has a lot of good information about the services that we offer. And of course, workshops that we are conducting in the area if you care to take advantage of that. Also, for those of you that are tuning in today, if you call that toll-free number, 800-700-1980, we're also giving away our retirement guide. It's a great, good piece of information. So it costs you nothing. All you got to do is just call in, and we can go ahead and get that emailed over to you, and it'll give you some good information in looking at your retirement planning from that big picture, holistic approach that we always talk about. Now, today, the topic I want to discuss, because I get this all the time, especially when I do workshops, is people always have questions regarding trust, wills, power of attorneys, basically estate planning documents. We're fortunate enough today to have a guest on our show. His name is Joe Hudack. He is an estate planning attorney. He deals with trust, probate, trust administration, real estate law, and all the rest. Now, what I can tell you is that Joe Hudack is not just some random attorney that I pulled in to, do the show. He's actually somebody that we work with directly. We actually refer clients to him. So we do have, we not only have faith in him, but he's actually done my own trust documents as well. So this is somebody that we work with directly. Always done a good job for our clients, and actually done a great job for me personally. So that's why I wanted to bring him on the show today to cover some information. And we use him because whenever we're looking at things again from that big picture approach, like I tell everybody on the show, hey, somebody can give you a good investment recommendation, but depending on that recommendation, that might have a positive or negative impact on your taxes. It may have a positive or negative impact on your trust and will planning. So we want to make sure all those things are working together. And this is where whenever we're doing plans for clients, we always, call Joe and get his opinion, get his advice, and he puts his thought process into our planning. So with that being said, Joe, I want to thank you for being part of the show today. I know I've been trying to get you on for a while, and I appreciate you taking time out for us.
You bet. Thank you, Rick.
Yeah, no, my pleasure. And real quick, I kind of want to hit you with some common questions that the listeners are tuning in today. I know they're going to have, because these are the same questions people ask me on a consistent basis. And the biggest question is, well, what is the difference between a trust or a will? I have a trust. Do I really need I have a will. Do I really need a trust, or vice versa? And people are always confused about that particular topic. So how would you explain the differences between the two?
So great question, Rick. It's a question that we get asked quite frequently. People call up, say they need a will. A will is a great document. It tells the court, an important piece right there, what to do with your stuff. It tells the court how you wanted your house or your bank accounts to be distributed to your beneficiaries. The difference between a trust and a will is that the trust is an actual contract between the creators of the trust and whoever the trustee is, or the manager of the trust, so that the trustee, upon the passing or upon the events described in the trust, can pass and or distribute assets directly without court involvement. And the big benefit of not having the court involved, which is what you have to do with a will, the court requires a statutory period and a statutory fee to be paid to the attorneys and or your executors. And for instance, when we're talking about statutory fees, they're really high, and people are always shocked by exactly how high the fees are. In the state of California, particularly, we are based on a floating percentage of the value of the estate. And just an example I give clients is a $400,000 house is going to cost roughly $11,000 in attorney's fees. So having a will is good, but you're going to take 18 months to get through the probate process, and you're going to spend $11,000 in fees.
Yeah.
If you have a trust, you can get through the process in about 4 months. And normally the cost of going through a trust administration is a slight percentage of what it would be for probate.
Gotcha. And, sometimes people will say, well, Rick, I heard unless my estate is over $10 million, or they'll throw some random number like that at me, I heard that I don't need a trust unless it's over $10 million. What would you say is like kind of a threshold that maybe somebody should at least consider getting a trust done?
So it's particularly in California, if you own a house, you're going to end up in probate. Just the simple fact that you own a house, because houses, the real property limit is $56,000 or $65,000 right now. So if your house is more than $65,000, you're going to end up in probate. Bank accounts are $184,000. So if you have bank accounts, financial accounts, investment accounts, whatever they are, that are less than $184,000, then you don't need to go through probate. But if it's over that, you're definitely headed to probate.
Okay, good. Because that I know for sure I get all the time. And then the other thing I was going to ask you, I'll sit down with somebody and they'll say, Rick, I don't need a living trust. My real estate guy or my neighbor or my brother-in-law or somebody, they're always getting their information from random people and not necessarily estate planning attorneys. And they'll say, he told me just put the kids on the deed of my home and that'll completely avoid the probate process. And I can save the cost of setting up a living trust. Do you recommend just as a shortcut, just, throwing the kids down on the deed of the home and avoiding the probate process that way?
So I usually don't recommend that, because the people asking that question are usually the people who have been in their homes for quite a long period of time. And so if you've owned your house for a number of years, the problem with adding your kids to the title is that it causes a tax reassessment for real estate tax purposes on your home, which if you've owned the house for 10 years, the current market value has escalated and appreciated so high right now that your taxes on the property could be a multiple of 10. So now you're getting a whole new tax bill just because you added your kids to the title. So you tried to avoid the trust expense, but now you're going to spend all that money and more because you have a new tax basis for the house. So adding your kids is not a good idea because, number one, of that real estate taxes. Number two, the other problem is that if your kids are out doing things and they're active in the world and they cause a liability for themselves, now they have an asset in your home, and now their portion that they own of your home can now be attached by creditors. So now you're not protecting your own retirement, your own safety and security. You're now putting it at risk. So that's the other real negative of doing it.
Gotcha. And that's actually an excellent point. You're trying to save money on one hand, and it costs you 50 times more on the other hand. And then, of course, potentially lose some of your assets in lawsuits and things like that. And so, again, this is where, we always talk about the big picture approach. One thing I do have people ask me, or sometimes they assume, they say, hey, well, now that I have my living trust, am I protected from lawsuits? So I guess, how would you answer that question? Because I always get that. They think that, oh, okay, I got a living trust. This now protects me from lawsuits, because I heard that once you put your assets in a trust, it protects you from lawsuits, creditors, things of that nature.
Yeah, that's a great Great point. We get that question quite a bit as well, Rick. And the answer to that is no. A revocable living trust does not help you with creditors. Now, a lot of people are like, well, I'll just name the trust something other than my name so they won't know that I'm attached to it. And therefore, I'm going to hide my assets from my creditors. And that doesn't work either. When you have a revocable living trust, the court system looks at that as though it's your assets, not the trust assets, because it could be revoked. In other words, you could end the trust and take all of the assets out at any time that you wanted to. The only way to protect those assets is to transfer them to an irrevocable trust, a trust that can't be revoked, it can't be modified or changed. That would allow you to move those assets to an irrevocable trust, and it would be for the benefit of other people, your kids, for instance, and that irrevocable trust gives you some of that protection, depending, of course, when you create the irrevocable trust. If you're got a pending litigation and you create an irrevocable trust, it's not going to help you. But if this is done years before any incident happens with a creditor, you're a lot more protected. The problem with an irrevocable trust is it's not yours anymore. You've now moved it out of your estate into someone else's control. So if it was your primary residence, for instance, you wouldn't be able to live in the house without actually creating a lease agreement with the irrevocable trust and paying rent to the irrevocable trust. You wouldn't be able to determine when to distribute financial assets from an irrevocable trust. You would be able to help guide the investment of those funds, but you wouldn't be able to control when the money gets distributed or how it gets distributed. That would all be done by an independent trustee.
Wow. So then it seems kind of complicated, and obviously you have like almost, well, I guess no control really over the assets. So under what circumstance do you think somebody would even want to even consider that? Because it seems kind of scary to me, like personally, like, with just the way you're talking about it, I'm like, okay, that sounds a little scary to me, just giving everything away. And now, somebody else is in full control.
So what I would say, an irrevocable trust is really not something for those who are not what we would call high net worth. Somebody who's looking at estate taxes as a real problem in their own estate. We would use irrevocable trust planning for somebody whose assets exceed the exemption levels set by the IRS in the state of California. Right now, there is no, there's no estate taxes in California, but if it gets enacted, then there could be. So the current tax exemption is over $12 million. And for those people who husbands and wives, that would be 24 million. So if your estate is in excess of that number, then we use irrevocable trusts for planning purposes, a way to take benefit from the exemptions now rather than waiting until later.
Gotcha. That makes a lot of sense. So I guess for those that are listening right now, unless your estate is over 12 million as a single person or 24 million as a married couple, you don't even need to think about it.
Yeah. And then Rick, that number is set to change in 2026. So when the year 2026 rolls around, we'll wait to see what the number is, but it's scheduled to drop to about half of what that is. So that's when people who might be under the 12 million, but over the 6 million, they'll want to do some of that kind of planning if the number is going to drop, because you're going to lose that additional $6 million of exemption.
Okay. That's real helpful. And again, folks, if you have questions about any of the topics we're talking about here today, or maybe you got questions outside of the topics we're discussing, maybe you have questions about taxes or your investments or your pensions, or maybe you're under the windfall because you're getting CalPERS or CalSTRS or any of those things, feel free to give us a call, toll free, 800-700-1980. Again, you're listening to the Big Picture Retirement Show. And if you need to get a hold of Joe directly and you have specific questions for him regarding your particular situation, again, feel free to just call us directly, 800-700-1980. You can also reach us on the web at safeguardinvestment.com. Now, here's the thing. Sometimes we have clients that say, hey, Rick, if something happens to my spouse and I, there is a child that maybe we don't want them to get all the money at one time. Or maybe they have a child that unfortunately might, you know, have a drug addiction problem, or, you know, maybe a special needs situation. So would the trust be more advantageous in helping them with those scenarios as opposed to just a general regular will? Or how would you go about addressing those particular issues?
So when you're looking at those kinds of distributions to beneficiaries, a trust is a great document. A will is also good, but remember, with a will, you're still having to go to the court to have the court, authorize the creation of a special needs trust. In a trust or a revocable living trust, you don't have to do that. The trustee can automatically set it up based on certain circumstances. So for those people who have special needs children, the special needs trust can be set up immediately upon their passing, and money can be funneled there for the special needs child. It protects the special needs child from losing government benefits. It also gives the trustee the options and the mechanisms to make distributions to the special needs child. As far as distributions to kids who might have some challenges in life that are not what we would call special needs, like drug addictions or other things, you can stagger distributions at any time. So for instance, a child who's got a drug addiction, and you say, hey, I want to protect them from the money because I'll think they're going to blow it on drugs. You can stretch distributions out. Distributions can be named for certain things only, like education. You can set it up for them to go to rehab. You can set up different milestones that they have to achieve before they start getting distributions. So you have full control over what to do in both the trust and the will. But again, the will is not the best way because you have to go to probate.
Yeah. So those of you that are listening to the show right now, I can tell you, Joe's been amazing in helping clients with those decisions, because a lot of times people will come to us and they'll say, hey, Rick, I got this issue, that issue. I don't know the best way to handle it. And, since Joe has seen so many different scenarios, he can actually make recommendations and say, hey, here's some suggestions for you, and put together a plan that'll fit your particular situation. And so I literally have seen scenarios, whether it be somebody that was drug addicted and they wanted their child to be drug tested over a period of time. And if they pass a drug test and they get a certain amount of money, everything from that to special needs to even pets, making provisions for pets, believe it or not. So anything under the sun, if you got questions, concerns about those things, trust me, he's a great source to help you figure that stuff out and make some recommendations to make that decision process a little bit easier for you. And again, just give us a call, toll free, 800-700-1980. If you're just tuning into the show, you are listening to the Big Picture Retirement Show. Again, I'm your host, Rick Rivera, and we're sitting here with Joe Hudack. And Joe, another question that I get often, and some of you listening to the show right now are going to relate to this. They tell me, they go, Rick, listen, I love my daughter-in-law, I love my son-in-law, but I got to be real. God forbid my son or my daughter gets a divorce. Is there any way we can set it up in the trust to protect at least, this money not becoming subject to, a divorce down the road, and now my son-in-law or daughter-in-law is getting a percentage of my assets and off with somebody else? So what kind of solutions or is there any in order to resolve that particular concern?
That's also another fun one that we deal with sometimes, and that is the question of are the spouses of my children entitled to a portion of their inheritance? And the answer to that is, in California, no. An inheritance from a parent or another individual that gives you something, it's considered an inheritance or a gift, and it's not a community property asset. The only time an inheritance from a parent becomes a community property asset and could be subject to a community distribution in a divorce case is if the child takes the distribution from the parent's trust and then puts it in a joint account with the spouse. then they've converted it. So can a parent protect the trust or the assets from their son-in-law, daughter-in-law? They can, by creating a trust for their child for their money to be distributed into, so that that separate property trust of a child would then hold the distribution from the parents. And that trustee could be somebody other than their child. It could be another child. It could be a brother, sister, somebody else like that. So that's one of the ways to do it. The other way is educating your children, making sure that your children understand that the money they're getting from you is their money. It's not their spouse's money as well. And that way they can put the money directly into their own separate bank accounts. If they're investing with Safeguard, they can have Safeguard set up separate property accounts for them so that the investment money is held separately and they control it. But if it's just an outright distribution of funds to the child and the child puts it in the joint checking account, there's a presumption that they wanted it converted.
Okay, gotcha. So then, so real simply, if they inherit the money, as long as it goes directly to a trust or an account that's just in that child's name, it's not joint account, but just in there, now we can protect it. But the second they commingle $1 into a joint account with the spouse, that then all bets are off.
Yes, for the money that they put into the joint account, yes, that money would then be considered to have been changed into community asset.
Okay, great. So again, folks, I know sometimes these topics can get a little complicated. So it's real important that for your specific situation, you definitely want to get a hold of somebody like Joe Hudack. But if you have questions about your specific situation and want to make sure you get all the details right, feel free to give us a call. There's no cost for us to, give you a 30-minute phone consultation. And again, that toll-free number is 800-700-1980. Again, that toll-free number is 800-700-1980. You are listening to the Big Picture Retirement Show. I'm your host, Rick Rivera. Now, we're getting close to the end of the show, and real quickly, and I hate to put time pressure on you, we got about a minute. Points of a power of attorney for healthcare management and also assets. And I know I'm cutting you real short, but can you tell us in about a minute and a half, something about those documents, how important they are to have or not have?
So we always prepare a power of attorney for financial management and a power of attorney for healthcare for all of our clients as part of the estate plan. It's an important document to have, but what gets overlooked sometimes is that the power of attorney also needs to be created for your children if they're over 18. Because once a child turns 18, then nobody technically can make the decisions for them until they're married, and maybe their spouse can. But power of attorney for financial management is super important because it allows your kids to help you manage your affairs when you can't do it yourself. Now, power of attorney documents for both financial and or healthcare will go away when you pass away. So they're great up until that point in time. So they help out tremendously in an incapacity situation.
Great. Thank you so much, Joe. So folks, that brings us to the end of the show. I want to thank Joe for coming on today. I'm going to try and drag him back on again sometime here in the future. And we'll talk about some other topics. And folks, feel free to give us a call. If maybe you just have some suggestions as to what topics you would like us to cover, give us a call toll free, and we're happy to take your recommendations. That way we consistently talk about topics that are important to you rather than a bunch of things you could care less about. Or if you have questions for me directly regarding your retirement planning or Joe, feel free to give us a call. There's no obligation. We'll be happy to give you a 15-minute phone consultation. Toll-free number is 800-700-1980. Again, our toll-free number is 800-700-1980. And also, if you call today, we will email you our retirement guide. And you can also reach us on the web at safeguardinvestment.com. So with that being said, thanks once again, Joe. Really appreciate your time. Everybody have a great day, and we look forward to talking to you next week.
Thanks, Rick.
Falling for you.